Good afternoon, Your Honors. I'm Gary Beasley. I represent the co-conservators, Dr. Catherine Byers and Jeffrey Byers in this case. I would reserve 3 minutes on a rebuttal.
3 minutes, yes.
You know, when I refer to a conservator or co-conservator, I'm going to be referring to Dr. Catherine Byers. There's no evidence that Dr. Jeffrey Byers has really done anything. He's more of a backup.
Yeah, he's a conservator, but she does 100% of the...
Correct, Your Honor. This, to give a little background, this is a conservatorship which began in New Jersey in 1981, involved a young lady by the name of Patricia Capelli, who was in a very severe automobile accident involving a semi-tractor trailer. Basically, she suffered severe damage, was in the hospital for over a year. She's now 62 years old, so she's been dealing with this since 1981. She lived with her parents in New Jersey, and this conservatorship was in New Jersey since 2000, up until 2004, and then she moved with her sister, Dr. Catherine Byers, here in Murfreesboro in 2004, and the conservatorship ultimately was transferred in 2015 from New Jersey to Tennessee. While from 2004 to 2000.
Now, she came here in like 2004.
Correct.
But the official transfer of the conservatorship was 2015.
Correct. The mother actually still continued, the mother and father still continued to serve as conservators. They just used the agent of Dr. Byers. And then she was added on in New Jersey as a co-conservator also. In 2015, it was transferred.
And the ward lived with her sister, in the conservator's home.
Correct.
Rent-free for 10 years?
10 years. This house was purchased in 2015. It's actually owned by the conservatorship. Prior to that, from 2004 until 2015, she lived with Dr. Catherine Byers and her family in their home on Ithaca Street. The ward has never had completed college. She's never been able to work. She's never had a family. She's lived with her parents the entire time up until 2004, and then she's lived with Dr. Catherine Byers. There was testimony at the trial of why that was, trying to make her life as well as possible, but she's been physically and mentally impaired that entire time. Now, there was testimony at the trial that she was very insistent. She's very insistent. She demands attention, and basically she needs caregivers 24/7. Now, luckily, there was a great settlement in New Jersey. I don't know how that actually took place, but they got a settlement that has provided a multitude of money for her to provide this kind of services for her. The portfolio right now of her...
If I may question, it's my understanding that Chubb Insurance, through that settlement, pays for all of her medical bills and most of her caregiving services?
She has regular Medicare and TRICARE, which pays for her health insurance. Chubb Care pays for anything else that is related to medical expenses, including caregivers. Dr. Catherine Byers each year submits an accounting of all the caregivers that she's had, all the times that they have spent with her. She has to document what they've done for her during that time, and then Chubb will actually make a reimbursement check of all the money that's been spent on the caregivers.
And one of the issues that came up is that Dr. Byers was not being reimbursed for her caregiving services.
Correct. That was one thing that Dr. Byers had not sought that. She thought because she was being paid as the conservator, she couldn't seek that caregiving, so she didn't split out the time. Yeah. And that really only is effective in 2020 when we had COVID. During that period of time, Dr. Byers could not get the caregivers that she had been hiring. She normally, since she started doing this in 2015, she had been hiring and vetting caregivers. So she had 4 to 6 to 7 people on her employee at all times, that they spent basically 100% of the time with the ward. When during COVID, Dr. Catherine Byers had to perform that function because she couldn't get anybody to take care of her during that time. That's important because ultimately the court, one of the reasons that it cut the caregiving time was because it said, well, Ms. Byers lives with her in her home. She gets the benefit of this nice home that she was living in. She lives there rent-free. And basically because of that, we're going to cut these caregiving time because I'm not going to pay her to sleep in her own room from 12 to midnight to 8 o'clock. Well, that ignored the testimony of the caregivers and Dr. Byers that basically someone has to be with this ward 24/7. The caregivers sleep in her room at night, and that's so she can get up and go to the bathroom. They can help her with that. So they take care of all of those issues. So the court failed to realize that when Dr. Catherine Byers has to do that, she has to do all those things. She makes her food. She cleans her up after going to the bathroom. She does the shower work. She gets her dressed in the morning. So when the caregiver's not there, that's what Dr. Catherine Byers has to do. So that's in addition to the conservatorship work, doing the accounting, filing the invoices with Chubb, doing all the stuff that goes into basically running a caregiver management company, paying the payroll, doing payroll taxes, W-2s, and all that. So ultimately, all of that work falls on Dr. Catherine Byers to do those things. This case actually started because Dr. Catherine Byers admittedly did not request permission of the court to do some remodeling on the home. And so that's what started this process. The Clerk and Master had some concerns with that very correctly, and we dealt with that issue. The court appointed attorney ad litem, Mr. Mark Polk, and he investigated the remodeling that was done, ultimately said that it did benefit the ward, and ultimately that went away. Okay, there was no need to make Ms. Byers pay back any of the money or anything like that as far as the remodeling. So that became a non-issue. Then Mr. Capelli, Joseph Capelli, intervenes. He wants to change the whole conservator. He wants to get rid of Dr. Byers. He wants to not pay her any more money. He wants to not have them live in the home. He wants to sell the home, put it on a smaller home. He doesn't like the home that was purchased. He says that was purchased more for the Byers family than for the ward. The Byers family was part of that process because they were going to be living with the ward, and they wanted to keep up that family environment for her.
A guardian ad litem was appointed at that time and approved the purchase of this house, and the court approved that purchase.
Correct. And the court had approved all of the invoices, fee invoices up to that point. The court had approved all of the accountings up to that point. There was issues on some of the accountings and so forth, but they were ultimately all approved up until this 2019-2020. All of the fee statements that were presented after the 2020, basically February 1, 2020 until December 30th, 2020, that accounting was what then became the focus of everybody as far as these fees and concerns were. All the other issues ultimately went away. The court did not, Mr. Polk had suggested that an agency should be hired to manage these caregivers because it was costing too much time for Dr. Byers was putting too much time on that, and so we should hire an agency to hire these caregivers. Well, the court ultimately found that you hire an agency, you get, one day they won't show up, one day there'll be a new person. Dr. Byers testified that her sister needed somebody that she was familiar with, that she knew on a regular basis. It was routine for her because when you change the routine, everybody is affected by the ward at that point. So that was what took place, and Mr. Mark Polk wanted to change the way that was done. Well, that went away too. There was no issue with that. The court said, this is fine. I like the way she's doing it. It's benefited the ward. We're going to keep everything in place. So ultimately, the conservatorship has not been changed at all. It is now going to be still continue to be done exactly like it's been done since 2015. The difference was that the court decided that I want to review these fee statements. And the court ultimately came back and basically said, on such and such a day, I won't give you, I don't have the exact amounts, but on such and such a date, I'm taking 2 hours away, I'm adding 30 minutes back. I'm taking 4 hours away, I'm adding 1 hour back.
And what was the basis for that? Was it just an arbitrary?
It seemed to me to be an arbitrary review of her record. Now, I know a judge, when he takes an attorney affidavit, he's able to look at that and he can sort of tell what attorney work needs to be done. He was an attorney before, and so maybe he can make that determination. I don't know that the judge had any particular expertise in knowing how much time Dr. Byers was actually taking on
Well,
this.
let me rephrase. That was probably a poor way that I asked that question, but did the judge give any basis for saying, for example, I'm going to take away 2 hours on this day, I'm going to add a half hour back? Did the judge make an analysis and a finding and look at it and say, I'm taking away 2 hours because I don't think these tasks were valid, or I'm adding back a half hour because maybe it was, or anything like, any explanation?
Some of the charges were for Dr. Byers supervising the remodel. And so he took some of those away. Those were a portion of them, but they weren't a great deal portion of that fee statement. His analysis, I don't think there was any more analysis than I just don't believe she's done the work. I mean, I didn't understand that to be the case as far as there being any analysis on his part, other than the fact he didn't think that she'd done the work, or that the work would have taken that length of time that she used. The thing that's inconsistent about this is this judge has approved a couple of fee statements prior to this time, and the prior judge who held this same court had approved all the fee statements up until from 2015 forward, up until this time. They all contain the same types of charges. They all contain the same general times that were used. They varied in terms of the amounts that were ultimately requested in fees, but they were all approved. Now, the Capelli, I think, will argue that there was no real hearings on this. Well, the judge always stands in local parentis to the ward, so it's always the judge's determination to have a hearing and make sure that these things are relevant and reviewed, and all the things were approved. As far as there are issues about the rate of pay. I run out of time, but as far as the rate of pay, initially the rate of pay was $75 back in 2015, and I put in the statement of the case in the appeal a very specific order that the judge found based upon his hearing that the case was complex, that it was taking time away from her normal profession, it was taking about 80% of the time away, and that she had no responsibility other than this conservatorship to take care of her adult sister.
That was June of 2016, that order?
Correct, Your Honor.
Was that the same judge as
It was not the same judge. It was, I think it was Howard Wilson, who was the chancellor at that time.
Okay. All right.
But
now,
then
there was originally a fee approval, I don't remember the amount, then it went to $75 an hour, then it went to $115.
As far as the amounts in Tennessee, they were all at $75 an hour. There was the one that was approved from New Jersey when the initial one started.
So it was $75.
75 was the initial one, and then they went to, in 2019, this judge, Judge Darrell Scarlett, did have the same hearing and found the same evidence and found it should be $115 an hour. Nothing changed about the evidence. He ultimately finds that the case is not complex, but there was no other evidence to suggest that it's not complex, and I would submit to you, based upon what this conservatorship has and the assets and the accountings and the fee statements and so forth, if this is not a complex estate, I don't know what would be.
Yep. I've got some more questions, so
Okay.
you can ignore that red light bulb. Except for COVID, since COVID, did Dr. Byers try to have a sitter or a caregiver 24/7?
She's always had caregivers 24/7. They come in stages. They work
Well,
eight.
I know that. There's always someone there to care for her. But was Dr. Byers hiring someone to do it 24/7, or did Dr. Byers always assume responsibilities after 10 p.m. to 6 a.m.?
No, there was always someone that stayed in the room with the ward overnight. So this was the full 24/7, that there was another caregiver. That's the reason Dr. Byers' other fee statements are not as much, is because she didn't have as much work to do.
So except for the COVID period where Dr. Byers was providing a significant amount of caregiving herself.
Correct.
Dr. Byers was not doing the caregiving. She was hiring caregivers to provide that service.
That's correct, Your Honor, and that's the reason she did not submit her time to check, because there wasn't any time
And
before
their
COVID.
fees were typically $25 an hour?
Her main caregiver, she pays $25 an hour plus overtime, and she stays at night with her.
So it would have been actually more than $25 an hour. It'd be
Correct.
$25 an hour, but they also got insurance benefits.
Health insurance, I believe.
Yeah, okay. So it was actually more than, it cost the.
It costs more, and it's a little illogical because we're paying them for all the time. One of the things the judge said was, I'm not gonna pay the conservator to watch I Love Lucy, but it ignored the testimony in the file that this ward needs the care 24/7.
Yeah.
And when no one else is available, Dr. Catherine Byers has to provide it.
And those caregivers fees were being reimbursed by Chubb.
Yes, they've always been.
Okay. Now, the financial assets at the hearing, it's my understanding, the amount of money under management was like $7.1 million.
Correct, Your Honor.
Okay. And then in addition to that, the house is worth $1 million to $1.2 million, something like that.
Correct, Your Honor.
All right. And there's no mortgage.
No mortgage on the house, and there's also, Chubb still provides, they pay a yearly supplement, which is up in the $100,000 range now, $200,000 range. And they do that for another several years, and then every 5 years, I think there's 3 more payments on the 5-year payments that come that are several $100,000.
So other than COVID and other than Dr. Vyer's conservatorship work, paying the bills, filing the tax returns, meeting with doctors and what have you, does the conservatorship have any other expenses?
No, just the maintenance on the house,
Yeah, okay.
that type of thing.
So you've got $7.1 million sitting there, and as the manager, the account manager said, the principal has never been drawn down on except to buy the house.
The principal's never been drawn down except to buy the house, and we did, with the attorney's fees from this case, we did have to get a $100,000
Sure.
removal to put in there.
Yeah.
But no other charges have been made, and his estimation that it would be $11 million, very conservative, when when all this is taken care of, comes from the fact that he was saying if we draw $300,000 from the corpus every year in expenses, if the expenses were that high, but there's never been expenses that high because Chubb basically pays the caregiver services.
And the ward, Ms. Capelli, has no children and no spouse.
No children, no spouse, her heirs are her siblings.
And if she were to die today, the petitioner, her brother, and the other siblings and or their heirs would inherit the $7.1 million.
Correct, Your Honor. Dr. Catherine Vyers, Robert Capelli, Joseph Capelli, Maria Clark, and then one sister is already deceased, but she has children.
Yes, sir. Thank you. Yeah. All right. Good afternoon.
May it please the court, Sumner Bolden of the Murfreesboro Bar. I represent the appellee. I don't want to jump around on you, but I think I probably will, in part after listening to appellant. It was apparent at the trial court, and it kind of is even here today, that implicit in the argument is that, well, the ward can afford it. And that's true, but it doesn't have anything to do with whether or not the conservator is properly managing the estate of the ward and whether some of these expenses should be incurred. And as the court just a moment ago talked about the 2016 order and then the subsequent 2019 order, there were findings about the complexity of the estate and also the fact that Dr. Byers couldn't work. She's a licensed psychologist. Come forward to the trial, and even before that, Judge Scarlett was troubled by some of the testimony that had been offered in those 2016 and 2019 hearings, and that's why he made specific findings in his findings and conclusions that are appended to the order that we're here about today. He found it not to be complex at all, and I suggest correctly so, because the money sits with a manager, of course, but it's just a passive investment. I don't even know that the manager does much at all either, other than just reallocate from time to time in order to to keep the balance of the.
Well, isn't it complicated to hire people to provide 8,670 hours of personal care service a year? Isn't that complicated?
I guess that depends on what complicated.
24/7 care?
I think it's not. I think it's burdensome. I don't know that it's complex.
Well, I would put those two together. Isn't it complicated to do tax returns? Isn't it complicated to pay the bills? Isn't it complicated to go with the ward to the doctor's offices, and isn't
Well-
it complicated to make arrangements for the ward to go to the swimming pool at the YMCA down the street?
I don't think that's any more complicated than what all of the rest of us adults do that have children.
Well, if it's that easy, why hasn't your client been doing it?
Well, he can't. He admitted he
Yeah,
can't. He lives in.
That's right, he can't.
No,
And he hasn't.
That's
And
true.
he won't.
That's also true.
And his sister has $7.1 million available.
That's true.
For her care and comfort and support.
That's true.
And his sister and the ward sister has been providing, in essence, 24/7 care since 2005.
True.
That's a burden.
I don't mean to suggest
That's an
otherwise.
incredible burden. Just knowing that you're supposed to be there next week to do it is a burden.
I can't disagree with the court. The only thing that I'm
Who,
attempting,
who are we saving the money for?
I don't know.
Just don't spend it
No, sir. I think
because it's not wise to spend?
the point of the trial court was you can spend it on the ward all day long, but if you're deriving a benefit yourself as conservator, that's inappropriate.
Well, what if Dr. Virus quits today?
That would be bad. And even the trial court recognized that the ward should not be
And
removed.
she's under no obligation to continue.
Oh, no,
No.
I agree.
And we all know that there are some fine assisted living facilities around, but her sister, her brother-in-law, her nieces and nephews won't be sitting there with her, and her long-term caregivers.
None of those statements I can disagree with. All I can do is deal with what was presented in the trial court and what the trial court found and concluded. And
To be fair to the trial court, it is important to avoid wasteful spending, and it is very proper to assure that someone is just not selfishly profiting from someone else's difficulty. The trial judge was very good and honorable and caring to be cautious about the expenditures, but if this ward had $300,000 in the bank, we would have one conversation. But we've got $7 million.
yes, I mean, there's no dispute about that. But that does point out to this court what you already know, and that is Judge Scarlett heard the proof and you know, in an appellate court, you don't hear it. And so he made those determinations based on the testimony that he heard over a 2-day trial. And he frankly was disturbed about having been told previously one thing only to find out it's another.
Explain that. What was one thing and what was another?
Well, I brought up complexity a moment ago, and we can argue about what
We can argue about that. Tell me about why he cut the fees from 115 to 25.
But it's at least two reasons. One of them was that he, quite frankly, didn't believe Dr. Virus when she had previously testified that she was unable to practice psychology.
Did he say he didn't believe her? Did he make a credibility finding and say, I don't find her to be credible?
He, on that point.
An express credibility
On
finding?
that point, he did, yes, ma'am. And what he said specifically was, she was given the opportunity at trial to answer the question, can you still work? And she wouldn't do it. And that is specifically in,
And that's in the record?
I'm sorry.
And that's in the record?
Yes, ma'am, it is. It's in the court's findings and conclusions that are appended to the judgment. And
Well, what is a reasonable fee for Dr. Byers' service?
well, I think the methodology that the trial court used was appropriate, and that is there's certain things that are, you know, are worth X amount of dollars. 115, use that as an example, if they're complex or they require something beyond simply being in the same house at the same time.
Well, to be candid, under these circumstances, my impression is that the $115 per hour is excessive, clearly for caregiving services. But to find somebody to manage and oversee 5 employees, file taxes, file accounting and medical expenses for insurance reimbursement, file accountings with the court, oversee substantial assets. Admittedly, that's not onerous, but it could be mismanaged. Overseeing the health care and well-being of the ward, scheduling and attending appointments with ward's multiple health care providers, managing medications, consulting with legal professionals.
So,
These are not Mr. Beasley's words. These are the trial court's words in the 2016 order, and there's nothing in the record that proves this otherwise. Nothing.
well, first of all, it's not.
You're not gonna find anybody to do this for $25 an hour.
Not for the things that the court just read, no.
No, but the last order that we have, I don't care what you do going forward. I don't care if it's conservatorship work or caregiving work. It's $25 an hour.
He did.
That's what it says, isn't it?
He did.
Okay.
Now,
I've got a problem with that. I can't speak for my colleagues.
I gathered.
I got a real problem with that.
Yes, sir, I gathered. Let me just, I guess, in order to give you some frame of reference as to how this even arose, the fee request, I think it was for 2020, of $132,000.
They were large.
Got the trial court's attention specifically because in addition to that amount of money, Chubb had paid another $190 for what you can't really tell in looking at the records, but clearly some of it was duplicative because it's healthcare related, and that includes caregivers.
And I agree with you, and I agree with the trial judge. Those fees got my attention too, and at $115 an hour for caregiving work,
Yes,
I fully respect the trial judge's concerns and the responsibility to see that a ward's assets are well managed. I
Of course,
fully agree.
if some of that caregiving work is at a sacrifice of one's profession, then that's a consideration too.
I'm sorry, Judge.
Would it not be a consideration too in assessing the fee that you have to, that this lady had to essentially give up her profession?
Well, the record doesn't bear that out. As a hypothetical, yes, I agree, and the statute
If she
says so.
loses 80% of her client time, doesn't that deserve some consideration when figuring out her fee for caregiving?
Yeah, as a hypothetical, absolutely.
Okay.
But the proof in the record doesn't show that.
Okay, we'll see.
And yes, sir. She was given the opportunity to testify about it, and she didn't do it. And to the contrary, she said that she hadn't worked full time in years. She had daughters to raise, and you know that's life. I get that, but that's not the proof. Didn't substantiate the 80% suggestion. Now when the court appointed the attorney ad litem as when he got this fee request, that's the first time shortly thereafter when there was notice given of the hearings that were going to occur in this matter that any of the other siblings were given notice. And it's not the appellee's suggestion that they did something wrong, that they didn't get notice of prior conservatorship proceedings because the statute said they should and they didn't. It's just a fact. They didn't know about it, and the appellee for the first time said, "Gee, this is there's something wrong here."
Didn't the siblings know that this conservatorship had been in place for many, many years? I mean, we're talking 1981. That's
Of course.
almost, that's
Of course.
over 40 years ago.
Yeah, of
And
course.
so they knew it was going on, but yet But you're not saying that they were entitled to notice.
No, I'm not.
Okay.
I'm just saying that that's what triggered the sequence of events, that no one was aware, or at least the appellee wasn't aware of the substantial fees that were being charged, and that's what precipitated the whole thing. Now, I really am gonna jump around a little bit now to get in my time, but
We'll give you a couple of extra minutes. We gave him some.
One of the things that I'm not clear that I understand from the appellant's perspective is the prayer for relief says we want you to reverse the trial court and just approve the fees in toto. And I don't know how the court would parse that, but even if it was otherwise something that the court would do, that takes out altogether the trial court's supervisory authority and obligation under the statute to look at this stuff. And that's what he was doing, and quite frankly, had Mr. Capelli never appeared on the scene at all, that's still the trial court's obligation, since the conservator is acting as an agent of the court, and he has that obligation. And in determining whether or not a conservator should be paid and how much a conservator should be paid, he has to look at whether or not those services were rendered for the conservatorship, and you'll find that he found many instances where he didn't deem that services rendered to the conservatorship. Then he has to go through the reasonableness question. He clearly found that on many occasions those fees were unreasonable, but the reasonableness is not simply to amount, it's to time. And that's a lot of the exercise that the trial court was going through in looking at these charges item by item. And this court can see it if you look at it. Dr. Byers had very specific, detailed timesheets, and the trial court felt that a lot of those things were not for the benefit of the conservatorship.
Did the court make and you probably heard me ask your opposing counsel this earlier, but when the court went through and started making these deductions and saying, I'm taking off 2 here, I'm taking off 1 here, I'm adding back a half here, did the court give explanation as to the reason for each of those? Because in the transcript that's attached, which is lengthy,
Yes.
it looks like there are some pages where it just goes down through, I'm taking off 2, I'm adding back 5, I'm taking off 3, and it just seems to be just going down a list, but without rhyme or reason as to why that occurred.
He did, and it does read like that. What happened, and I think if the court will look back at that ruling, he predicates those calculations by saying this is what I've gone through and done, because he'd already done the calculations. He was just announcing it in court, and I know that I don't know what particular function I can bring to mind, but it doesn't take this long to take out the trash or whatever. That's the process that he was going through, and there's no better way to do it. And quite frankly, had there been no adversary proceeding, had it just been the conservator submitting a request for fees, well, I mean, per statute, the trial court is going to have to act on those requests for fees, and it's going to have to go through somewhat of the same process. Otherwise, the statute's meaningless. That just means he's supposed to rubber stamp whatever's put in front of him, and that's not what's required of him. So I understand the question, but if you go back to the beginning when he started these calculations, he does attempt to explain how he's doing it.
Well, I read that, but it wasn't extremely enlightening, other than the fact that he did say it gave him a headache because he had to wear his glasses. So I didn't understand I did not follow the reasoning there, and that's why I ask you: was there reasoning somewhere that I missed?
Well, no, not in the sense that you could do that. Say if you were talking about a car mechanic, because they always have a schedule of how much time something takes, which you never really know if it does or doesn't. But He did what he could with what he had. He was clearly troubled by what he had in front of him, and he attempted to do what the statute says he's supposed to do and determine reasonableness.
Well, let me ask you one other question. From the court's ruling, I was not clear on one other thing, and perhaps you can enlighten me as to maybe what your client's position was and how this came about. But it seemed to appear from the court's ruling that the court said basically if there's time when Dr. Vyers is at home and she is functioning as the caregiver at that time for her sister, that she should not be paid for that time. I know there was a reference, if they're sitting and watching TV, that she shouldn't be paid for that time, was my understanding, even though that she would be the caregiver on duty during that time period. Is that in line with what the court ruled?
In some instances, yes, and in the best I can categorize it or explain the difference is that when Dr. Vyers is home in the evening in her house, in the house that she lives in along with the ward, she shouldn't be paid $115 an hour just to do nothing.
Well,
So-
and let's just throw out the 115 figure. I'm
Sure.
just talking about paid period.
Sure. He does draw that distinction, and he's because of the unique situation, and that is, although the conservatorship owns the house, it's technically where all of them live together, and so he draws that distinction. He says, if you're performing caregiver functions, helping her to the bathroom or to shower or preparing meals, he has no problem with that. His problem was if you're going to be home anyway, so why you're asking this court to pay you to sit at your own house. And I do freely recognize that if it was an employee, third party, that person gets paid to sit there. There's no doubt about it.
Okay.
I didn't quite get done, but I got done what I could get
right.
done. So.
Well, before you leave,
Yes, sir.
I don't want my comments to be taken inappropriately. I applaud Judge Scarlett for his very sincere and dutiful effort to go through the record and try to make sure that the ward's money is not being misspent or that someone is inappropriately profiting from her substantial assets. And so I applaud Judge Scarlett for that effort. I've got some differences with the putting a $25 cap on no matter what the conservator does, and I've got some concern that COVID made things really difficult, and while the prior order of $115 an hour may be part of the culprit, which was a prior judge's order, but somewhere in the mix there's a reasonable resolution. But I applaud the trial court for fulfilling his duty of making sure that the ward's assets are not being misspent.
Yes, sir.
Thank you. Mr. Beasley?
Just a few things, Your Honor. With regard to the $115 order, that was Judge Scarlett who made that in 2019.
Okay, I thought that was the 2016.
And there
That's
was
my mistake.
That was the $75 order. And the implication that Mr. Capelli and his siblings didn't have notice of these hearings, and if they had, there would have been a more intense hearing, leaves off the fact that it was the judge's duty to make sure that all of these invoices were correct for all the other invoices that he had already approved years past, which had the same types of charges for the conservatorship. The COVID and the caregiving is a little different. But as far as the conservatorship, he had already approved several invoices on that basis. Your Honor, the credibility issue with regard to that, the only thing that I found as far as credibility issue, the judge said that Dr. Vyers was asked a question, tell me when you last worked full-time. And she had the opportunity to answer that, she didn't answer it. And therefore, Judge Scarlett found it was not credible on that thing. I think that's the only credibility issue there. Got to remember, she's been doing this since 2004. She hasn't had an opportunity in 20 years to work full-time. because she's been dealing with this. Finally, Mr. Capelli's position, if he says it in his brief, that Joseph Capelli is, I don't think a family member that's taking care of another family member in their home should be compensated. So that's where Mr. Capelli's coming from.
Yeah, that's easy to say if you're not the one that's doing,
It's not the
providing
one
the
doing
care.
it. And then the final thing is, I just completely lost my train of thought. As far as the fact that she was in the home and she's not doing anything and she's living in this home with her, the one thing I would suggest the judge failed to take into consideration was all the evidence that this ward demands attention. There was testimony in the record that she has short-term memory questions, so she will ask a question. 5 minutes later, she'll ask another question. And that's Dr. Catherine Byers dealing with that when there's no other caregivers there. Thank you.
Well, there's few things more important than caring for someone who can't care for themselves. And I applaud both of you for your work and Judge Scarlett for his sincere efforts to do what he believes is appropriate, and we'll do our best as well. Thank you. That concludes the docket.